Good morning, everyone. My name is Vanessa Stine, and I'm a senior staff attorney with the American Civil Liberties Union, or ACLU, of Pennsylvania, where I lead the organization's immigrant rights work. I began working at the ACLU in 2018 at the height of the first Trump administration's attacks on Philadelphia and witnessed the incredible power of our collective efforts to stand in solidarity with immigrant communities. My testimony today is going to focus on the current Philadelphia policies, how they work in practice, how they're legally sound, and how previous attempts to deny funding were defeated and failed in federal courts across the country. I know the current policies were discussed by the first panel, but I just want to touch on them briefly. The first executive order, which is commonly called the ICE holds policy, is about ICE detainer or hold requests that are sent by ICE to local jails or other law enforcement agencies to detain somebody for an additional 48 hours after their release date. These hold requests are not mandatory, and the executive order makes it clear that people in Philadelphia custody may not be detained solely on an ICE detainer, ICE hold, and I'm going to talk about later why that's important for the city to maintain that policy. The second policy is about prohibiting city officials generally from asking about immigration status or having police take immigration status into consideration. There's also a third policy that's a police memorandum, which is Memorandum 0106, which prohibits police officers from sharing confidential information about people who are immigrants except under limited circumstances. I want to talk briefly about how these policies work, but before that, I just want to acknowledge that these policies are often referred to as sanctuary policies, but that label is misleading. Philadelphia's current policies do not create sanctuary from federal immigration enforcement. ICE regularly arrests and detains people in Philadelphia, including after the adoption of these policies. Right? These policies date back to 2006, and the latest one is from 2016. And ICE presumably will continue to operate and arrest people here in Philadelphia. While they don't prevent immigration arrests, the policies play an important role in protecting Philadelphia residents and safeguarding the city from liability from flawed immigration enforcement operations. They're a common sense approach to local governance for several reasons. First, they recognize the importance of having trust among immigrant communities so that immigrants feel safe to seek city services, including from local agencies that enforce discrimination and labor laws, victim services, and public health centers. Second, these policies are fiscally smart because they prioritize scarce city resources to focus on local governance and leave federal immigration enforcement up to the federal government where it squarely belongs. And finally, these policies are grounded in a bedrock constitutional principle, the Fourth Amendment. The Fourth Amendment prohibits unreasonable detention by the government. Philadelphia's power to detain people rests on its power to enforce criminal laws. When ICE sends a hold request, they are effectively asking Philadelphia to detain someone for no legitimate basis, as Philadelphia has no independent authority to enforce federal immigration law. So the city is merely asking ICE to comply with the Fourth Amendment and produce a judicial warrant, which is sensible because it follows the law, but also because failing to do so can expose the city to liability. Courts have repeatedly recognized that state and local officials can be held liable for detaining people pursuant to ICE hold requests because they are merely requests, meaning they need not be followed. Philadelphia's other policies that I mentioned, which limit city employees about making immigration inquiries and sharing information, are also important because it ensures that city employees stay in their lane and don't go beyond their expertise. It's not the job of city workers to investigate a person's immigration status. And when that happens, it erodes trust between immigrant communities and those local agencies. It also can expose local agencies to liability, whether that be for racial profiling or other violations, which violates the Constitution's core promises of equal protection under the law and the Fourth Amendment. As many of you are aware, the city of Philadelphia sued the federal government when former Attorney General Jeff Sessions attempted to deny federal funding to cities whose policies protected immigrant communities by refusing to detain people on ICE holds. That litigation resulted in a victory for the city. The Third Circuit affirmed the district court's permanent injunction barring the federal government from withholding funding in this manner and finding that it had been unlawfully imposed. And the Third Circuit's not alone. Courts across the country, for the most part, agreed. And just to summarize, these are long-standing policies. These are policies that have been in place for some of them for over a decade, and they make sense not only from a fiscal standpoint, but also because it helps ensure that the city is not exposed to financial liability due to potential civil rights violations for honoring, among other things, ICE holds. And so we really, the ACLU of Pennsylvania urges the city to continue to stand firm in its commitment to being a Fourth Amendment and welcoming city. Those are what these policies do. That is who the city, it's who the city has said that we are, and we should stand firm in that. And we also welcome further discussion about ways that policies could be strengthened or added to provide further protection and make it clear that it's not the job of local authorities to engage in federal immigration enforcement. Thank you.